Okay, hello everybody. I'm Ben Worthy. I'm a lecturer in politics based at Birkbeck College, University of London, just over there. And I want to thank Judith and James for all their hard work in putting this together. I was trying to think of a variety of justifications as to why 2016 is a significant year for openness. So we're going to reflect on openness in the UK in 2016 because firstly, it's been 250 years this year since the very first piece of openness legislation, which is the Freedom of the Printing Press Act in Sweden. I'm going to look carefully at Maurice as I do this. It's been 42 years since freedom of information first appeared in a party manifesto, which was the Labour Party manifesto of October 1974. It's been 16 years since freedom of information gained royal assent, 11 years since its operation, 7 years since the creation of data.gov.uk, and as of the 1st of June 1916, it's been 100 years since the very first mention of the words freedom of information in Parliament, when a Liberal MP, Richard Holt, said, "If there is one matter on which I feel more strongly than any other, it is that in a democratic community, the foundation of good government lies in freedom of information, freedom of thought, and freedom of speech. That is essential to good government. It is quite true," he went on to say, "that if you grant that freedom, there will be abuses. It is quite true that foolish people advocate foolish views. That is one of the many unfortunate corollaries." And he said that in reference to a debate about religious abstention from conscription and being part of the war effort. So we've got plenty of anniversaries to think on, and we've got two fantastic speakers plus me. So without further ado, we're going to all speak for about 15 minutes or so. When it gets to 15 minutes, I'll nod to the speakers, and if I get to 15 minutes, I'll nod to myself very severely. And after that, we'll, of course, open it up to your questions and comments. So we'll go Maurice first, followed by Heather, and then me. People always say they don't need any introductions, but I really don't think we need very much introduction. Maurice, as you know, has been one of the founders of what was the Outer Circle Policy Unit that then became the Campaign for Freedom of Information in 1984. And you've been a director ever since then. And as you all know, he's been at the forefront of the campaign around the recent independent commission that looked into the Freedom of Information Act. And Heather Brooke, Professor Heather Brooke from City University, began life as a criminal journalist in Washington and then moved over to the UK. Sorry, yeah, I just realised that. Sorry. A crime reporter I've written down here. I'll try again. Heather Brooke began life as a crime reporter in Washington and moved over to the UK. And you may have heard that there was a little bit of scandal over MPs' expenses around 2009. And Heather had a very large part to play in that. But actually, she's used freedom of information far more extensively and is the author of Your Right to Know, which is a guide to using the Freedom of Information Act, and as well as a number of other books. Most recently, The Revolution Will Be Digitised. So we're really grateful that you've come along to speak. So without further ado, Maurice, your 15 minutes begins now.
Thank you, Maurice. Can I just ask who is not very familiar with the detail of the Freedom of Information Act? Who's not very familiar? So if I said to you, Section 35 and Section 36, who would not know what I was talking about? Okay, that's fine. Okay, one little hand has gone up. Okay, don't be shy, please, because if you all tell me you know, then I'll probably say things that are above the heads of people who've been too shy to say they don't know. All right. Well, I'm really going to talk about what has just happened, which is the setting up and publication of the report of the Commission on Freedom of Information, chaired by Lord Burns and featuring Jack Straw, Michael Howard, Alex Carlile, and Patricia Hodgson. I've left their titles off, but they're easier to recognise without the titles, I think, probably. And this was set up to review the operation of the Freedom of Information Act in a number of specific ways, but the ways all pointed towards a concern that the restrictions might need to be tightened up to provide greater protection for sensitive information, and a suggestion that the Commission ought to look at whether more is needed to be done to protect authorities from the burdens of freedom of information. So the context looked pretty unpromising. It looked as if it was set up to come up with proposals to restrict the Act. And the fact that Jack Straw was on there was particularly significant because he has made his views well known publicly over a number of years. And in effect, he's expressed views on all the key terms of reference, all of the key terms of reference in the Commission's brief, suggesting that the Act had gone too far. And so it looked very much as if this was set up to lead to restrictions to the Act. And the immediate prompt of the review looks like it was the Supreme Court's ruling in the Guardian Prince Charles case, where the case had gone to the upper tribunal. The Commissioner had said this correspondence should not be disclosed. It had gone to the upper tribunal, which said it should be disclosed, and the government had vetoed that decision of the upper tribunal. The Guardian judicially reviewed the veto, and the Supreme Court found that the veto had been used unlawfully. And that would have concerned the government because it removed a tool it believed it had had since the Act was passed. What it hadn't confronted, and what hadn't been confronted during the passage of the Act, was everybody had understood, and it had been contentious in its own right, that the veto could be used against decisions of the Information Commissioner. I don't think anybody had focused on the possibility that the veto could be used against the tribunal or the superior courts, and the upper tribunal has taken over the functions of the High Court under the Act. So this was a superior court of record, and this made the use of the veto in this case particularly contentious. So what the government obviously feared is the first use of the veto had been against the tribunal's ruling that the cabinet minutes on the decision to go to war in Iraq should be disclosed, and that was the first use of the veto, and that was a veto of a tribunal decision, but in effect what was equivalent to the lower tribunal. So it didn't quite raise the issues that vetoing the upper tribunal. But obviously, from the government's point of view, it was now faced with a prospect that on a repeat occasion, if the tribunal said cabinet minutes or something which they regarded as equally sensitive should be disclosed, they no longer had the power to stop that happening. They piled on various other things on top of that. Had they just restricted themselves to that issue, I think the outcome might have been quite different. But they piled on a decision to look at whether sensitive information generally was protected, whether policy decisions were protected, whether cabinet papers were protected, whether risk assessments were protected, and the whole issue of the burden. What then happened was there was a massive response to the public consultation, 30,000 responses to the Commission's consultation. The press absolutely savaged the government. It had no friend amongst the press. Unlike its proposals to reform or abolish the Human Rights Act, it had no friend in the press. In fact, the most vigorous opponents were the Telegraph and particularly the Daily Mail, which absolutely went for the government. And just before Christmas, the government effectively capitulated, and the key minister declared his love for freedom of information and his hope that the Commission will not recommend any changes to weaken the Act. The Cabinet Secretary said all he wanted was his veto back. He didn't want to do any damage to the Act. He thought that was wonderful too. And so we then had the Commission having some public hearings, which were most notable for Michael Howard grilling the former Cabinet Secretary Gus O'Donnell about why Lord O'Donnell, thought there should be new restrictions on access to policy discussions. I mean, it was a famous piece of theatre which you can watch on video if you haven't had the chance to see it. The Commission published its report on the 1st of March. The night before, Matt Hancock put out a statement in the press saying government would not make any legal changes to the Act. That indicated that all the key proposals that had been floated, all of which required legislation, were unlikely to be supported by the government. when the report was published, or just before it, the Cabinet Office published a response to the report which didn't contain that statement. So the report came out, 3/4 of the recommendations involved legislation. And we didn't know what the government's position actually was. And this was then pursued by journalists who were told by the Cabinet Office that they weren't standing by the statement. The statement made the night before was not government policy. The journalists then went to the Downing Street briefing and asked the Prime Minister's press spokesperson, who said the statement the night before was government policy. And the Cabinet Office, press office, then announced the statement the night before was government policy. So everybody trying to respond to the act was trying to do it in a fudge of ambiguity about where the government actually stood. So the position seems to be that legislation is not going to be made on the basis of the Commission's proposals, except for the possibility that changes to the veto may get legislative backing if the arrangements the Commission has proposed don't work on the current basis. So that's where we seem to be. Now, what we had feared would happen from the way in which the terms of reference were drawn out was that the public interest test would be removed either permanently or for a period of years from the exemption dealing with policy formulation in government. Possibly there would be a new exemption for cabinet papers which would not be subject to the public interest test. And possibly there'd be a new exemption for risk assessments which would not be subject to the public interest test, or at least for a period of years, for a period of time, no doubt years. And the Commission has said it's been persuaded that the public interest test works well in relation to those types of information, and it hasn't recommended removing the public interest test. What it would have said had the ministers not announced 3 months in advance that they were surrendering, whether it would come up with the same set of recommendations, same statements, unknown. They've also said there'd be no charges for making FOI requests, which is the next big thing that's been feared. On the third thing that we had feared, which would there be substantial changes to the cost limit, so that to make it easier, substantially easier for public authorities to refuse requests. They've pointed in 3 ways simultaneously. They've said the cost limit should be increased in line with inflation. That means it's harder for public authorities to refuse requests. I mean, I think that's a problematical suggestion in its own right, because there's absolutely no need to do that. Secondly, they've said that redaction, the time spent by authorities blacking out exempt information, should be allowed to be taken into account, but for the absolute exemptions only, which I think is puzzling, I find. And then they've said that if that happens, it should be possible to override the cost limit on public interest grounds, which is something else that we supported. So they are pointing, I think, in 3 different ways at the same time on that. But anyway, those are the main threats where the threat has not materialised. The areas where I think they have indicated more problematical things is, first, they've called for legislation, which presumably isn't now going to emerge, to make clear that the public interest in protecting confidential discussions is not eliminated the moment a decision is taken. Now, I mean, that is a remarkable conclusion for them to come to, because that's not what happens. The public interest in protecting discussions is not removed the moment a decision is taken. And I mean, we produced 20 pages worth of analysis of the decisions to show that, because we knew that Jack Straw's view was, expressed view was, that was the case, and it's just not the case. But anyway, that has now featured in the Commission's proposals, and they have called for legislation to enact that, which I suspect is, Jack Straw getting his way on this point. I doubt that the Commission is really in doubt about what the correct. One of the notable things about the Commission's report, and we were amongst quite a number of people who went to see the Commission at their invitation before it took place, was Lord Burns said, "I've been reading the Information Commissioner's decisions." So the moment he said that, we heaved a sigh of relief, because that indicated he was taking seriously what was actually happening on the ground, as opposed to simply listening to what officials and ministers were saying. And what he said then, and what he said at the public hearings, were, "I'm finding it difficult to find examples of sensitive information which have been disclosed with damaging consequences for government in this area." So I think that was also a relief. So it's puzzling why they should have come up with that particular finding, which is not explained, and the consequences of which are not explored. The second significant thing they've said is they should cut out the right of appeal against the Commissioner's decisions to the first-tier tribunal. And I think they did. That was a question put to us and to perhaps one or two other people during the hearing. We said that we didn't think that was a good idea at all. I mean, their figures are that 21% of requests of appeals by requesters are partly or fully successful at the first-tier tribunal stage. But that's quite a reasonable, significant success rate. I mean, it's certainly true that some requesters make hopeless complaints to the Information Commissioner, are rejected, and then make equally hopeless complaints to the tribunal, but avoid being struck out as having no reasonable chance of grounds of success, because it presumably it's not apparent to the tribunal at that stage that they haven't come up with a great new argument they didn't put before the Commissioner. But I'd be very, very unhappy if the Commissioner was in effect given the final word, subject only to appeal on a point of law to the upper tribunal, because I don't think the Commissioner's decisions are of consistently high enough standard to justify the removal of the oversight of the first-tier tribunal. I won't go into them at the moment, except to say that in 2010 the Commissioner published on the same day 2 decisions involving the same public authority, reaching diametrically opposed conclusions on absolutely the same issue. I mean, that's the kind of problem. Yeah. The third issue that's come up has been that they are calling the proposals on the veto, which require legislation, and here the Commission is saying the veto should be clarified on a statutory basis, and they've accepted a proposal which the Commissioner put to them. See, the problem they have is they're not particularly, I don't think anybody was particularly keen to carry on vetoing the tribunal, let alone the tribunals, let alone the courts. So the Commission said they should restrict themselves to vetoing the Commissioner if they thought the veto was necessary. So the problem that and we've always said we don't think there should be a veto at all, that the appeal mechanism is perfectly adequate for dealing with cases where they think the Commissioner or the tribunal gets an issue wrong. There shouldn't be a veto at all. Government doesn't accept that. Commission didn't accept that. But their problem is, what do they do when the Commissioner supports the government? And it's only, as happened in the Prince Charles case, at later stages that the need for a veto emerges. And that's what's caused them the problem. So what the Commissioner has suggested is there should be some kind of positive endorsement of the Commissioner's decision, which in fact removes the right of appeal to the tribunal. So they can either veto a decision of the Commissioner which they don't like, or they say we like this so much that we're going to veto any alternative decision that might be reached at a later stage. And that is, in effect, what the Commission is proposing and the government has accepted. And the danger of that is that it may promote more use of the veto than otherwise would happen, in order to get their veto in early enough to avoid the dilemma of having to do what they now accept they shouldn't be doing, which is vetoing the courts, tribunals or courts. So I think that is a problem which we may find in the way the veto is used. On the other hand, what we've seen is 7 vetoes in 10 years, 2 of them repeat vetoes of previous decisions. So the veto has not proved to be the kind of major obstacle, the major routine obstacle to decisions the government didn't like. There had been feared, so we just have to wait and see what happens. They've also put in a number of positive recommendations. They've said there should be improved statutory time limits for dealing with requests. There should be, for carrying out internal reviews, should be a requirement on larger authorities to publish their compliance statistics, to publish disclosure logs. There should be legislation to make the shredding offence more effective so that it doesn't have to, that it can apply even if it's not exercised within 6 months. They support the idea of contractors, larger contractors being brought in directly under the Freedom of Information Act. So they've come up with a raft of positive recommendations, which are arguably outside their terms of reference, but obviously the great weight of public opinion has led to this. And they've thrown in a quite useful suggestion that the Cabinet Office, now it's in charge of FOI, should remind public authorities that they should not refuse requests because they fear that their decision to disclose one piece of information will be a precedent which will force them to disclose subsequent, more sensitive pieces of information. The Commissioners tactfully avoided pointing out that it is the Cabinet Office that is the main culprit under this heading, and so the question is whether the Cabinet Office is going to be capable of responding to this broad hint that it should reform itself and stop being such a bloody nuisance about it. And it's clear that we've had examples in which they've basically spent probably £20,000 or £25,000 of legal costs avoiding revealing how often a committee on deregulation, a Cabinet Committee on Deregulation, has met, even though there's no conceivable harm from revealing that number, which they've now revealed is 13. So they've now revealed it's 13. It's had 13 meetings. They spent £25,000 trying to avoid, my estimate is £25,000, trying to avoid revealing that. And their only reason for doing that is they fear if they revealed how often that committee met, they wouldn't be able to avoid revealing how often a committee dealing with something genuinely sensitive, where the number of meetings might well indicate something that was going on that people didn't. They wouldn't be able to avoid disclosing that. Well, I mean, that's just stupid, because on the facts, they can reveal a trivial statistic and legitimately withhold and be supported by the Commissioner of the Tribunal in withholding a very sensitive statistic. So the hope, probably forlorn, is that the Cabinet Office will become less defensive about defending disclosures which can perfectly well take place without harming any government interests. But I think we have to wait to see whether that happens. So that's where we are. We still have to wait to see what the no legislation actually means in the longer term, whether any of these things will resurface. I think the main threats are off the table for 18 months. That's about the life cycle between major attacks on the Act. So watch this space in 18 months' time for all these issues to be reopened again by this or a different government. No, it would obviously be this government.
Or maybe not. You heard it here first.
We won't have a new government in it. We won't have a new government in 18 months.
Great, fantastic, Maurice. That was really, really interesting. And if you can just hang on to any questions you've got, I'm going to now pass over to Heather. Heather?
Okay. So I'm going to talk about, using FOI on the ground. I used to make a lot of requests myself. I made about 500 to 600 from 2005 to 2010, and then I got just a bit exhausted, or perhaps disappointed by the whole thing. Maybe I just got a bit sort of worn down. But now I supervise about 50 students doing freedom of information, doing investigative journalism projects based mainly on FOI. So I see how the law's panning out for them. So I'm just going to speak to the question about where are we now in terms of openness. So when I first started making FOI, there really isn't a People think, oh, nothing's changed. But actually, if you were back in the day, as I'm sure Maurice will remember as well, it was really, there has been a big change in terms of the culture, in terms of what you can get. I don't think it's by far as advanced as it should be, but it certainly has changed quite a lot. When it was a huge deal just to ask for really basic, what I thought was really basic civic information, like how much do public officials get paid. Even to get their bans, it was considered a state secret. When I was writing Your Right to Know, my first book, I was even trying, in part of that book was a directory of Freedom of Information officers, and even trying to get the names of the Freedom of Information officers used to take me hours battling with switchboard operators and civil servants and public officials to try and get their names, to try and get directed through this sort of switchboard and find the right person, and then I would. And sometimes they would be fine with me putting their name in, and other times they really were against it. And I remember the holdout agency, I managed to get most all of them in, and the holdout agency was a highways agency who just point blank refused to tell me who their Freedom of Information officer is, as if it was a state secret. And actually I felt that was illegal because as part of the law, there's a section in it, section 16, which puts a statutory duty on every public body to provide advice and assistance to requesters in order to help them formulate their request. Because any requesters do need that because they're outside of the bureaucracy and are trying to understand the inner workings of the bureaucracy. They don't know all the metadata of a database. They don't know how information is collected and stored. And so it just makes everybody's life easier if you can actually just talk to an FOI officer and say, are you the people that record bike thefts? If so, that's great. I'm going to make my request to you. But a lot of times it was difficult just getting these names. Now I don't think that would be a problem. But there's still battles about pay. The top levels of pay are genuinely I think that's been accepted, that it's going out in the public domain. There's no expectation of privacy about what senior officials, public officials, are getting paid. How it goes down into the lower levels of pay is still very hotly debated. I know in my own university, I just went through a pay review as a professor, and I had to do my pay review based on 0 facts because all of the professorial pay is secret. And so I have to say I'm not getting paid enough based on no evidence because it's only through rumor that I know what other people are paid. So we're still, I feel like there's been some progress, but it hasn't totally fed down into all levels. So when the government came in 2010, this conservative, well, it was a coalition government at the time, they did come in after the MP's expenses on a big transparency mandate. And I don't know if everybody remembers that, but they came in. If you read their manifesto, it was invitation to join the British government. And Nick Clegg gave a speech when he was made the Deputy Prime Minister that really took to heart, I felt, a lot of people's anger at being sort of locked out by this elitist system that just where public officials were using public resources for private benefit. And he said that's not going to happen anymore. We're going to we're going to have this big, bold openness. We're going to start publishing all kinds of data. We're going to publish the coins data, which is like the more detailed budgetary data. We're going to publish all contracts above £25,000. We're going to publish all spending detail above, I forgot what that was, £500 perhaps. Yeah, £500. And these were some of the things they were gonna roll out. And to be fair, they did roll those things out. And they also embarked on an incredibly progressive and bold open data movement. I have criticisms about the open data movement, but a lot of the people that were put in charge of the open data websites were remarkable. And if you ever look on opendata.gov, data.gov now, it's an incredible website, and you can really get right into what you want in a way that was not possible in previous administrations. So that's that's good progress. Where I feel that the progress hasn't really shifted is it's perhaps when you come right to the center of power. So that is the Cabinet Office, that is the intelligence agencies, that is the sort of real center of government, the Ministry of Justice, perhaps the police. And here I find that there's still this this elitist ideology, which is that these people believe that they are entrusted with power and to know what's best for everybody else. And they don't really see much of a role for the public except to retrospectively ask for their approval every 5 years or so. But in this elitist system, there really isn't any need to keep, because the public aren't, they're not interested in the public consent in real time. They just look for it afterwards. There's really no need for them to be informed. It's sort of in real time as well. So when you come to start asking for more detailed information about the heart of government, and particularly what really matters, which I would say are decisions and policies, then it's a real lockdown. And this is what Maurice was saying. This is where the government is really fighting hard to keep its its privileged secrecy. I wrote it, my second book was called The Silent State, and in it I juxtaposed these two strange things that were happening in Britain, which was this massive rollout where the state was very intent on making the private citizen going about their private business transparent through surveillance. And I documented all these ways of surveillance, not just the CCTV cameras, but all these government databases. And this is only increased with the investigatory powers bill that's coming. I think it was just debated yesterday. It's an incredibly draconian bill. It would make Britain famous for all the wrong reasons. It's just like an absolute affront to any country that calls itself a democracy, that bill. So this sort of attack on a citizen's right to be left alone by government, but at the same time very jealously guarding the state very jealously guarding its own privacy and keeping itself secret. And I feel like this is what the veto power is about. It's about it's a very sort of entrenched way of thinking that nobody is above, nobody can challenge our view of what the public interest is. Only we are able to determine the public interest, not the people themselves, not the courts even. So that's really what the veto is about, and that's why the Prince Charles letters were so challenging, is because here was Rob Evans from The Guardian thinking, I feel like I have a really good public interest case I can make about why these letters that Prince Charles writes to government ministers should be in the public domain. Everybody else who writes to ministers has to be, you can make a public interest argument that they have to be disclosed, their names have to be disclosed under freedom of information laws. Why should the royal family be any different? In fact, they should be held to a higher level of accountability because they are so much more influential. So he thought he had this argument. He took it through the appeals, and the tribunal also agreed that there was a strong public interest. And then it was vetoed, and then, as we just discussed, it went to the Supreme Court. And the Supreme Court also ruled that the tribunal was capable of deciding what was in the public interest. And now this is what really seems to grate on the executive, is like, how dare anybody besides us be able to determine what is the public interest? And for me, that's the that really goes to the root of the problem in this country, is that we've sort of got a democracy, I would say democracy in quotes, where we've gone from having an executive, a sovereign that was a monarch that was the sovereign. Then we've had Parliament that is sovereign through the powers of the royal prerogative, but we haven't yet moved to the people being sovereign. And so that's really where I feel the next step needs to go, is that we need to challenge this idea that only Parliament has the right to decide what is in the public interest, and that the courts and everybody else has to be subservient to what Parliament thinks. That's a bit of a ramble, but that's yeah. So that's I think I've covered everything. Oh, the only thing I would just add is that when I saw that the Commission had reported, I was relieved to see that no curtailments were coming down the pipe for FOI, but also I was cautious because, as has been said, this does every few years there's a move to try and shut down FOI, and usually by imposing fees or making the fees more so that they cost out sooner. So there was an attempt in 2007. There was another one in with a private member's bill, I think, in 2008. When I won the High Court victory about MPs' expenses, it was there was no ambiguity about that ruling. Like, they had to disclose that information. And we debated all the permutations about what could and couldn't be disclosed, and including the addresses of the MPs, because that was the only way to determine whether the claims for the second homes were legitimate or not legitimate. And we heard from the Parliament said it would be dangerous, and they didn't have any evidence, and the judges ruled that it was in the public interest to publish those addresses. Well, that happened in May 2008. In July, an MP, Julian Lewis, put through an amendment to a totally unrelated bill that would change it so that MPs' addresses would be exempt from that disclosure, and it just went through, and so that happened. Then in January of 2009, Harriet Harman tried to introduce secondary legislation that would have amended the FOI law to exempt the House of Commons altogether, which would mean that all of the information that was being scanned in, all the expense information that's being scanned in, would no longer have to be published, because as the privilege of being the legislatures, you can make the law and you can change it to fit your needs, and that's what they were trying to do. And that got rumbled by the press, and they had to back off. But what I noticed is that they had this tendency, when they couldn't win the public argument and they couldn't put through legislation on its face, they would try and do these sneaky things like secondary legislation, statutory instruments, to try and sneak under the radar these unpopular curtailments. So I would just say I remain cautious. I guess I remain eternally vigilant to ensure that they don't curtail these rights we have.
Great, thank you, Helen. Okay, so I just offer a few thoughts as well. My name is Ben Worthy. I'm a lecturer in politics at Birkbeck. Before that, I was at the Constitution at University College London. We spent a few years doing some funded studies of the impact of freedom of information, central government, local government, Parliament, universities briefly. And since then, when I moved to Birkbeck, I've been doing studies of the impact of publishing open data, particularly financial data at local government level. And I've also been working with the Open Government Partnership. Most recently, I've been finishing a book about the development of freedom of information, why do governments pass FOI laws, looking particularly at the UK. And it will be available in all good bookshops as soon as I finish writing it. And in summary, I think, and I'm hoping Maurice is going to agree with this, governments find freedom of information acts difficult to resist in opposition and difficult to back out of once they're in government. I want to offer kind of just an overview of where we are in terms of openness. I want to give three kind of areas of success and three areas of scepticism, or to put it a bit less academically, 3 reasons perhaps for you to be cheerful and 3 reasons for you to be a little bit preoccupied. The first success, I think, is the Freedom of Information Act itself. which is the kind of foundation stone of lots of the openness that we see around here, as Heather pointed out. It was a rather different world before the Freedom of Information Act. We found in our studies, it's not just that Freedom of Information Act has put more information out there, but it's definitely made public authorities more transparent and more accountable. Internationally speaking, there's very high levels of use of the Freedom of Information Act in the UK. And some of the benefits are rather hidden. We calculated that around 80% of FOI requests were to local government. And that freedom of information is a local tool for people to find out information of use to them. Now, we very rarely see this except in what remains a local press, but it means that there is a real kind of information feed happening. As well as the usual suspects that have been opened up by FOI, and I mean, you can imagine the Ministry of Defence, parts of central government, local government, there's a whole range of other bodies that we've learned much more about. If you think few people were expecting the monarchy to be opened quite so much by the Freedom of Information as it was, not least because parts of the monarchy were taken out of the ambit of the Act in 2010. One of my favourite examples is Walberwick Parish Council, where the entire parish council resigned following FOI requests over a planning issue that they seemed to be trying to not attract attention to. And this has not just led to more transparency and openness, but also shifts in cultures and behaviours within bodies. Now, this is not consistent across bodies, but there has been shifts in behaviour, propensity to publish more information, more open cultures. And one of the wonderful things studying freedom of information is to look at some of the unintended consequences. So, unintended consequence one, the creation of the Independent Parliamentary Standards Authority. Unintended consequence two, the Recall Act of 2015, which allows citizens in certain circumstances to recall errant MPs. In terms of technology, you have things like whatdotheyknow.com as well. So you see all these things kind of democratically happening. I think what the Independent Commission really showed to us was that freedom of information isn't just a law, but it is also a powerful symbol of a way of doing politics and attitudes towards government that is supported across the national press, the local press, and civil society. To quote David Clark from a long time ago, it's very few issues that are supported simultaneously by the Daily Mail, the Daily Telegraph, and the Guardian. And freedom of information is one of them. I think Rick Snell, who's a great academic over in Tasmania, talks about the kind of radical simplicity of freedom of information. It's very chaotic, it can cause disruption, but that's kind of how democracy should be. The second reason for cheerfulness is the expansion of openness, because it's not just the Freedom of Information Act. Think about all the laws that allow us to access information. You've got the Environmental Information Regulations, data protection, even last year's Consumer Credit Act made estate agents publish certain types of information. You can now use social media in local council meetings. The Freedom of Information Act itself has expanded to cover network rail, partly accidentally. The Environmental Information Regulations has been a very significant case, which looks like they could also cover utility companies. And as well as the kind of legal changes, you have the knock-on effect of the 20-year rule instead of the 30-year rule on records. And then you have, like Heather's mentioned, open data, which is opening up all sorts of information. Not just in the public sector, but also in the private sector. As of next month, Companies House will be publishing data on all UK registered companies and their owners, which will be published in a usable form. And you may have noticed the mayoral election and David Cameron, there's been talk about opening up the property market and property ownership, particularly in London, following allegations of there being some black money involved in certain areas. And it's not just the data, but also the innovations that come from it, the creation of various applications and tools that allow people to search and use this information. One great example is Where Does My Money Go?, which has a brilliantly explanatory title. It uses data from HMRC, and at the push of a button you can find out what parts of your tax go where. If you do want to waste an afternoon, I strongly recommend you go on Twitter and go on ParlWiki, because that is an app that allows you to know when a computer with an IP address on the House of Parliament estate makes a change on a Wikipedia entry. Now, you don't know who's making that change, but very often it's rather easy to work out because of what it is that they're changing. And just taking a step back, the third reason for optimism is what all this means. It does look like there is the emergence of what some people are calling a kind of new ecosystem of openness. There's a new kind of fluid set of people and instruments that are, as Heather said, eternally vigilant about what public bodies are doing. So there's, in terms of transparency, there's the Freedom of Information Act, there's open data, there's leaks, there's whistleblowing, all the way to some of the mega leaks, which we know about, Snowden, etc. And there's lots of people willing to hold bodies to account. Some of these are NGOs, some of these are formal watchdogs, some of these are informal watchdogs. I'm thinking of the Taxpayers Alliance, who spoke at your event. Some of them are citizen activists, old media, new media. And they're all watching, and some people have gone further and said that this is how the new democracy will look like. As people are doing less voting, less engagement, this will be what one academic calls a monetary democracy, where there's the elites still on the inside, but a whole range of different people watching for all sorts of different reasons. Now the skepticism. I think we've all worked out that there's some sort of 18-month to 2-year rule on happiness with FOI. Yeah, I got 2 years, so I'd set my calendar for January 2018 when we can all reconvene and discuss what's happening. Very few governments fall deeper in love with FOI over time. You may have seen the Obama administration was revealed this week to be behind the attempt to sabotage reforms to the Freedom of Information Act in the US, despite promising to be the most transparent administration ever. There's a law of kind of diminishing enthusiasm. What's interesting is while FOI symbolises outside something very good, I think you can see, at least in parts of government, FOI symbolises something very bad. Now, I'm not sure if it symbolises unhappiness at people asking difficult questions, or if it feeds into this wider argument about the chilling effect. You may have heard Gus O'Donnell say that he believed that officials were making pro-FOI, pro-EU arguments in their head because of FOI. And all these claims about the chilling effect, also about the resource burden, which again came up. One of my concerns is that without actually doing anything, governments can row back on freedom of information. They can do that through resource cuts, which are a silent killer of freedom of information in Canada and Australia in the 1980s. And secondly, by contracting out and outsourcing. It's very unclear whether the insertion of a FOI clause in a contract really makes a difference. Second reason to be a little less cheerful. Firstly, this conflation of open data and freedom of information is rather difficult. Freedom of information is the right to access information. Open data is the publication for public reuse of data that, in most terms, the government thinks you might find quite interesting. And that's not the same thing. And conflating them, as some politicians have done, gets us into a rather tricky area. Secondly, there's a conflict over what this openness is targeted at. I've talked to you about a few of these wonderful things about the private sector. The government is very keen on talking about private sector openness. And if you were feeling cynical, you could say that's because it takes attention away from public sector, central government openness. Notice these attempts around beneficial ownership and tax transparency are also politically symbolic in taking action over the issue of tax avoidance, which is kind of grown in intensity. And thirdly, there's a conflict over what exactly this openness is designed to do, particularly over open data. Of course, civil society talks about the democratic benefits. Governments have started talking about the economic benefits, which are a bit less clear, and also the social benefits, talking about social capital. And just as a final thought, I think as the Regulation of Investigatory Powers Bill goes through the House of Parliament, and I spent some time yesterday today reading about it, and it is much more scary than I thought it was. There is the opposite side of the argument, as Heather said, because the debate about transparency parallels another debate about the transparency of citizens to the often secretive surveillance of parts of government and intelligence agencies, and indeed increasingly private companies. And there's a bit of a blurring between those different bodies. When we talk about big data, open data analytics, unfortunately, one of the few organisations to do this on a huge scale is the National Security Agency and the UK intelligence agencies. And I think one of the big areas of discussion for the future is over to what extent is it possible to make their actions transparent to some degree to the citizen, which was part of the intention and discussion around the regulatory investigative powers bill. But it isn't exactly clear how that will work in issues around oversight. So, reasons to be cheerful, reasons to be a little more guarded. And maybe we'll open up to questions now. Okay, any questions? If you can just say your name, it feels like a game show. Where are you from? And we can get rolling. Questions? Critiques?
Perhaps I can give a comment. My name is David Borden. I was a former civil servant in Customs and Excise in the Cabinet Office, and I'm now a community activist in the planning field in my local area in Vauxhall, Kennington. So and when I was in government, one of my jobs was in information law and freedom of information, and when we violated your convention rights, but we did so in an impeccably convention-compliant manner, and so on. So I've seen the beginnings of FOI in government, and it was really dispiriting in terms of anyone who wanted to, believe in the concept. It was individuals sort of wanting to know about the background to their non-promotion, or it was businesses who hadn't had the benefit of some facility which someone else had, and were effectively collaterally appealing against it by finding out why it was. So it was a bit dispiriting to begin with. I dare say somewhere in there, there would have been eventually, something you said, oh, that's very interesting, or yeah, I'm probably interested in that. So I was a bit dispirited about it when it started from the inside. From the outside, I've used it perhaps a couple of times a year, and I've seen the results against the Mayor of London, against Lambeth Council, against public bodies in relation to planning. And there it's been half working, half not. I've used the Freedom of Information Act, I've used the Environmental Information Regulations, and my goodness me, we've got to have a lawyer read every single page of this document, and that would be so expensive that we couldn't let you have it. It's a supererogatory expense in order to say you can't have it on a class document, which the tribunals held that you ought to be entitled to. So I've had sort of interesting revelations. At Vauxhall we've got a lot of building going on, a lot of tall buildings that don't actually conform to any of the plans, and you wonder, how did that happen? And you glean something from a planning application somewhere else, but says, oh, there was a seminar, which it was all decided how we did this sort of thing. So you ask for the minutes of the discussion. Lambeth Council, the Mayor, Wandsworth Council, Cabe, who actually chaired it and organised it, no record was kept of this seminar. So you look at a couple of planning applications and discover that the major developer, made a presentation showing how wonderful his large buildings were. So there's been some revelatory material. There's been some stuff which, if anyone had asked previously, would have been told, but which is produced comfortably. Large developments give rise to large sums of money in community infrastructure levy. How's it going to be spent? Well, we've got a group inside the council who, decide how to spend it. And how much money? Oh, about 24 million, but no one's actually consulted anybody about how it's done. So it's, from my outside perspective, it's been a sort of people's subpoena, which has sometimes yielded useful results. But from inside, it was a disappointment.
I do wish that some of the members of that commission had actually been users of FOI rather than receivers. It always seems that the people that are on the panel to examine the law always come at it from the civil servant side or the politician side and not the user side. Because, I could tell you all of my idealistic students who use the Act and they're super excited. It's their first real engagement with the political system. And they have these kind of utopian ideas about how everything's going to work really efficiently and everybody's got everything together. And then they get their responses back. And sometimes they'll get good responses, but a lot of times they get really disappointing and unsatisfying. I would say even because we have to do tutorials to help them to write the requests in the language that they can be answered in. And even when we do that, they'll get responses back that just really dispirit them, because you'll just think that why couldn't that really should have been answered, and it could have been answered, and one felt that the person answering it was going out of their way to find reasons not to answer it just for the hell of it, not for any real purpose.
Any thoughts, Maurice?
Well, a key bit of the equation is the approach that freedom of information officers in public authorities take. And unfortunately, they are subservient to people above them who very often don't understand the Act, don't understand how the provisions work, and are less committed to the principles than those people are. And so, the system works. In some places where the system works well, it's down to individuals who are not being interfered with by the people above them, either because they're trusted to make sound decisions, probably because they are trusted to make sound decisions, and because they've demonstrated that they're experienced in the workings of their own authorities. Where those people are junior officials, then I think the system is likely to fail. It's bound to be a slow process in the first instance because they can't take decisions on their own authority. And they're quite likely to make bad decisions as well because they don't understand the legislation properly.
One of my best results was in the run-up to a public inquiry where we were objecting. And we asked for material about studies about tall buildings and boxes that happened. And because counsel for the council in the inquiry was the one who was asked to decide what ought to be disclosed, he disclosed more than the council would have liked, because he'd insisted, that, well, that study, yes, but that study also has got to be disclosed, which was interesting because it just happened to be then you got a superior who had to be obeyed, so to speak.
Yeah, well, I mean, I was astonished when I went, particularly in local government, but also in central government, the different kind of range of views, even within one body, and the different levels of awareness at the top of the organisation, and the views of the FOIs would not necessarily reflect people above them. And sometimes, you forget that there's sometimes a battle going on inside about what happens here. One thing I do find fascinating is the view of very senior politicians, because the big question is, how often do they actually see an FOI request? And I think there is a kind of fire station effect where there's a few people at the very top of government telling each other stories about how horrible FOI is. Two different books on New Labour speak about how vexed Tony Blair was with the FOI request about Chequers. And it was apparently the one FOI, not about Iraq, the FOI request about who would you have over to Chequers, and it was Jerry Halliwell and Arnold Schwarzenegger given an iPod and all these things. And that was what really vexed him. And it's very interesting how they get to meet it. They probably see very few FOI requests. The ones about them, the ones that are very sensitive, and the ones that other people tell them about. And then it was very revealing when Gus O'Donnell was questioned by the Justice Committee in 2012 about, give us some examples of the chilling effect. And he gave one, which was the coalition negotiations, the most unique event in British political history for about a century. And then another two, one of which was hypothetical. And so it's very interesting effect at the top of organisations.
He gave the same example to the FOI Commission when he was pressed by Michael Howard to come up with examples of the chilling effect in practice. He came up with the discussions between the coalition partners where he was asked, is this FOIable? And he said, well, it may be, and I can't guarantee it won't be disclosed. He said that to the Commission as well. But actually, and so the two parties met without officials present, so there'd be no notes which could be disclosed under the FOI Act. But actually, 3 days after that meeting took place, there was an FOI request made for any minutes, but also for any papers. That was refused, and the requester challenged it to the Commissioner, and the Commissioner said it should not be disclosed. Very sensitive material, it would be damaging to the interests of good government, not to allow the parties to negotiate privately. Now, Gus O'Donnell ought to know that. I mean, he's used that example in at least 2 major inquiries, and he's not acknowledged that actually the decision, and what he was saying was, it's the throw of a dice. There's absolutely no way of predicting what the outcome will be. But actually, it is very predictable. It is predictable that the system would not order the disclosure of material of a high-level sensitivity as that at a time when it could have direct implications should there be another coalition discussion between other parties. Right? It's significant that he doesn't mention that, but just cites the example as an objection.
But I don't think they're actually that interested in evidentiary policy. I don't think they're actually interested in evidence. They make a show of being interested in evidence because that's we're meant to be making evidence-based policy. But I've seen it twice before. Once when Charlie Faulkner, the previous Lord Chief Justice, was trying to introduce fees in 2007, and he said that public bodies were overwhelmed with vexatious requests, and I was so annoyed about this that I put an FOI into his office and said, "Please give me a list of all the vexatious requests that you have cited." And he answered by giving me 6. He could only list 6, and they had all been culled from the newspaper, so they'd been published. So actually, those were the only ones that he knew about. So it wasn't the fact that it was this actual problem. It was just such a big thing, taking up all their time that they had to change the law. It was like, I don't like being asked these questions. Let's find some ruse we can use to make it look respectable as to why we want to shut down this law. And it was the same with the MPs' expenses about their homes as well. When they put the argument they didn't want the home addresses to be made public, because at the time they were published in the electoral roll, and they wanted them to be taken out. And they said it was very dangerous and that there was threats all the time that constituents were threatening MPs. And so the judge asked them to bring some evidence to the table, and they had none. 0. There was no police reports of where MPs had filed a police report about threatening constituents who had threatened them.
Any more questions, thoughts, ideas? Maybe I'm going to take a few, if that's all right.
Sorry, yeah. Andrew Goodfellow Swap. I've been an FOF for 10 years. So if I've refused any of your requests, I apologise, or any of your students. And it's kind of something that echoes a lot of what's been said already. I'm very familiar with the kind of battles that you talked about. And what I've noticed in my own experience is at the beginning of FOI, in 2006, strictly, the FOI officer had the power because they were the ones that read the Act and looked at it and knew, as far as anyone knew, what was what. And organisations, or certainly the organisations I worked at, were very poor. They were very possessive over their information. And that has improved substantially, hugely over the period. But what's also increased, and what seems to be reflected with central government that you've talked about as well, is the input of communications and marketing and media into those responses that they feel are going to have a certain negative impact on their organisation or the leader of the authority or something like that. The feeling I come away with is that it's more about control of information. They want control, and they're getting smarter at choosing their battles. So whereas before they really, councillors and the like really didn't know what to do with it, now they know, okay, some things can go, some things maybe we need to word about how we phrase this, maybe we need to think about how we interpret the question itself. So people are still getting responses, and this may reflect on the kind of responses that your students are receiving. They may get responses, but what they're getting is bland, meaningless pointless. I just wondered if that was kind of that conflict between media holding on to stuff and actual freedom and actual openness. Something that maybe
I'm just going to grab a few more questions.
My job was an independent information management training consultant, and sort of following on from that, I was just wondering whether there was any view about Heather's point about like data and information quality. Another point is information overload. People requesting information just being sent everything, and therefore the onus is on them to interpret it, to sift through the valuable information. I remember once I was working in the government department as a contractor to go for a project with somebody, and I was just given their mailbox to sort out what had happened. It took me weeks. I don't know ever to the bottom of what happened, but it's just this information overload. And then the third piece is, does this prompt a need or a development of, if you like, information literacy, information awareness amongst the citizenship in order to actually deal with this increasingly sophisticated state machine that's using PR and spin to actually push information out, and only the information out that they want to do. I mean, that sounds a bit conspiracy theorist, I know, but I just wondered whether there are any reflections on those on the panel or the rest of the audience.
Maybe we'll just take those two questions. I think it is important that we forget that the rise of freedom of information has been paralleled with the rise of spin, almost exactly. And the two things aren't necessarily going hand in hand. So there's a question, is there more game playing? And also, is there information overload, and what do you do about it?
Well, I mean, I haven't seen authorities using this tactic of information overload very often, I must say. I mean, usually authorities don't want to disclose something, don't shower the requester with a massive amount of information. They just don't disclose anything. They shower them with a massive number of exemptions. I mean, the overload is coming probably in the open data sets where stuff is being chosen. I mean, I was overseas 18 months ago, and somebody asked me, they said, we always thought Britain was a very secretive country, but now we hear you're the most open and transparent country in the world. How did you achieve that? I said, our government just announced that it was. And very few people in the UK believed it, but it's harder to challenge it from a country a long way away. And so,
the Chinese premier who actually announced it.
Yeah, I wrote about that in The Silent State, about this rise of propaganda and spin. And again, I feel like it comes from the same political elitist attitude that I described earlier about curtailing FOI. Because again, it's to not trust your electorate with the ability to make up their own mind. And so you want that is the definition of propaganda. You don't allow people the freedom of thought to come to their own conclusion. You want them to come to the conclusion that you want them to come to. And that's what spin is. And I find it particularly dangerous in public bodies because usually they're monopoly providers. So if a store is doing a bunch of propaganda or advertising and PR and stuff, they have a lot of competition. But if your police force is putting a lot of energy into PR and reputation management, there isn't another police force you could go to if you didn't like the first one. You're stuck with that one. And I've always followed the sort of mantra of Joseph Stiglitz, which is this kind of economic theory that the way that you have to keep these monopolies honest is there has to be a free flow of information, because that's what identifies problems when they're small so that they can be fixed. And if you don't allow the free flow of information, it basically is you're just creating this vicious cycle within the organization where bad practices go unrecognized, and because they're unrecognized, they're unfixed, and then they just become worse and worse until they develop into catastrophically dysfunctional organizations. So I feel like PR and spin looks appealing in the short term, but I think there ought to be some academic studies that would show, perhaps you could know of any, that would show in the long term it's actually very damaging to the reputation of those institutions. So you're buying short-term goodwill for long-term distrust and disfavor. Yeah.
Can I make a point on that? I would have thought, if anything, there's an argument to do something about the royal prerogative or crown prerogative. And before Tony Blair died, he actually wrote on that. Not that long ago, David Davis, as a member of the cabinet, he tried to put forward a private member's bill. It was struck down because the Prime Minister didn't want it. And this is the trouble, which is what Lord Hailsham, the late Lord Hailsham, said, as you'll be well aware, that the Prime Minister is an elective dictator. And, really it's an issue that goes to the very heart of the constitution of this country. And it's not until we sort of identify all the different flaws of it, we see there's need for root and branch reform.
There's, I thought it was very interesting when Jeremy Corbyn refused or apparently refused to kneel at the Privy Council, because all of my students suddenly wanted to ask me what the hell the Privy Council was. And all the kind of old oaths. I mean, Peter Hennessy says the oldest secrecy oath in Britain goes back to 1250, which is the Privy Council's oath. Just some interest. The interesting point about game playing, we did look to see if there was much game playing when we did the research. But I suppose it's kind of like a successful crime. If it was well done, we wouldn't have spotted it. There is some interesting research from Canada where some government departments do have very sophisticated systems called amber lighting systems, where they actually flag up very early FOI requests that may be problematic. I think the issue about overload, like Maurice says, is much more to do with open data. There's also quite a lot of politics in open data. The problem is that open data looks so wonderfully neutral, but it's highly political. Fascinating research in the United States. Federal departments refuse to release any up-to-date data, not because they didn't want the public to know, they didn't want other departments to see it in future spending rounds. Local government complained to me, some people in local government complain that why does central government have to release spending over £25,000 and we have to release it over £500? Cue local press stories about phone bills, bar bills, hotel bills, etc. And there was a fear that it was being used to make local authorities look profligate. So all sorts of fun there. And there's lots of interesting research about how people take in information. And dare I mention the name Donald Trump. There's some very interesting research about the difference between an uninformed voter given information and a misinformed voter who, even if you present them with information, continues to believe what they did before, possibly even more strongly. And one of the fascinating things about openness is that it's shaped by the environment around it. In the UK, it's actually a very low trust country compared with a country like Canada. Rob Ford, the mayor, the former mayor of Toronto, even after he did what he did, was still more popular than David Cameron was relatively in the UK. So systems are shaped by kind of wider popular attitudes. So the great thing about the MP's expenses was not that it was a revelation to most, but actually it was a confirmation. And this kind of leads back to your point that some of the arguments, and I think you've made this argument, Heather, is that in some senses freedom of information is an antidote to spin. Because lots of people had a sense that something was going on, but only when you got the document could you be sure that it was happening. That you could be sure that you could find that, and you could get the raw document unadorned relatively by any spin, etc., etc.
Yeah, I would say, so I trained as a journalist and worked in America before I came to Britain, and data journalism was very developed there when I left. And when I came here, it was nobody had ever heard of it. And for good reason, because there was no data, and there was also no statutory right to government or official information. So you couldn't do anything anyway. And so you had a press that was totally defined and existed in a different information landscape, like what I would call a patronage system. And I wasn't used to it. So, and I didn't know how to play by those patronage rules, and I felt like they were sort of corrupt, and I just didn't want to get into it. So I really liked FOI because for me it was a kind of way to do clean hands journalism. I didn't have to do any favors for anybody. I didn't have to wine and dine people. I could remove myself from the whole like PR gang that sort of, you know, hunt in packs around through Fleet Street. And it was just a way to just get to get raw, unspun data. And it's like a kind of judo, I guess, it's a sort of a journalism judo that you can use, because you're using the government's own information against it. I mean, I didn't go in with the purpose of like, oh, I'm going to get you. I just go in to figure out what's going on. It's very rare that an FOI is going to be like the smoking gun on a story. It just gives you a bedrock of facts. That's why I always kind of find it like amazing that ridiculous people like Chris Grayling say, oh, all these lazy journalists using FOI. It's like, what? So lazy journalists who base their stories on facts and empirical data rather than just something they've heard at the pub. It's like, I find it bizarre.
There was another question down there. Yeah.
Evan Harris from Tax Off Campaign and Article 19. I've got two questions. One is, it was fascinating. So let's assume that there isn't going to be legislation, but I think one has to be very on one's guard. It's fascinating to work out why that is, because it's a great surprise that they marched Jack Straw, Michael Howard, Lord Birkbeck out up the hill, and then marched them back down again. It's quite an unusual phenomenon. Was it because the David Davis group, they didn't have a majority for it in the Commons? Did they worry that it was going to be normalised in the laws, where they clearly were going to run into problems, and they'd probably have amendments the other way, like the data disclosure arrangements for the private bodies performing public functions? Or was it because they just didn't want to have more criticism from the media, the United Media, or a combination of those? I think it's the panel's view. My second question is, what the landscape looks like in case law, if you know, in Strasbourg, or a freestanding or a more defined right to information under Article 10 that's applicable in our own jurisprudence. And if future cases do provide that, it will be an interesting challenge for the same media that's so strong on the right to information, that is not so keen on the Human Rights Act and having more direct Strasbourg influence in respect to the right to information on our law. And I've been to a couple of briefings where there are cases coming forward. Anyway, I'd be interested to know what the prospects are felt to be for our own jurisdiction from case law there.
Can we just bring in Judith? And can I also compliment you on the word marmalised? I really like that. I'm going to use it as my own.
Well, my question perhaps relates to that, as to one of the mechanics of openness, so thinking maybe a bit more broadly than FOI, but also the open data tools, and we talked about environmental information regulations as well. I mean, in stuff that I've looked at around courts data, one of the problems is sort of verifying some of the data that's coming out and actually having a check for that. How do we know that these stats are actually accurate? So I just wondered if you had a wish list for how these tools should be improved, and sort of what are your main complaints with the system, and how could we actually broaden now we've dealt with the restriction issue.
Maurice?
Well, I mean, why the government reversed itself? I think the government blundered. I think the appointment of the commission was politically inept to a very high degree. They could very easily have appointed a commission made up of people who hadn't declared their views, would have taken seriously what the government said were the government's concerns, would have listened, would have ended up looking at the pros and cons of the act and where it needed to be strengthened as well as restricted. And they would probably have made a lot more progress on their own agenda than they would do by, actually they were greedy. They just said, Supreme Court's opened up an opportunity or a need from our point of view to do something. Let's do the whole thing now. But I think their mistake was to put Jack Straw on it, personally. I mean, I think, they not only put him on it, but Michael Gove actually commended his views in Parliament 3 weeks before they announced he was on it. And the rest of the committee was based on the need to provide all-party balance around it. They could very easily have come up with an entirely different committee that people would not have rubbished, that people have been prepared to wait and see what they came up with, and what might well have given them more of what they were looking for without having its credibility completely destroyed at the outset. So I think that was it was their own lack of political nous that led them into the situation that they're actually in. As far as Article 10 goes, I mean, we'll wait and see. There's several cases, as you know, Evan, there's several cases going now to the Grand Chamber in Strasbourg, which we'll look at whether Article 10 does incorporate a right to information. I mean, the problem is Article 10 is not brilliantly drafted as an outline freedom of information law. It doesn't provide, and this is one of the reasons why the government, I think, has fought it and will continue to fight it vigorously. It doesn't provide the basis for some of the exemptions that government considers essential. There's no obvious basis for protecting internal deliberations of government or policy advice in the Article 10 list of permitted restrictions. There just isn't one. It obviously wasn't drafted with that role foremost in the drafter's mind, and so it doesn't stand up very effectively as a sort of a sub freedom of information act, because you've got to say, do we have the grounds to protect X, Y, or Z, which and you could have a situation where bodies not covered by the Freedom of Information Act in the UK become subject to an Article 10 right of access, and are then actually in a more exposed situation than freedom of information bodies. But of course, if you then have to take the Article 10.2 restrictions literally, you might have a difficulty sustaining the Freedom of Information Act in the light of a ruling upholding Article 10 as a right of access to government information. So I mean, it is a puzzle how, I'd like to see that happen. So there's a puzzle how that will be made to work in a way that meets people's expectations.
I'll talk to Judith's point, because I don't really, in terms of why did the Commission back down, it's only an anecdotal opinion, which is, I don't want to say it was the Daily Mail that won it, but I do think that had a big impact. Also, I believe there was that huge number of people that gave evidence. I think that was through, was it 38
degrees. Or 38 degrees.
Yeah, 38 degrees. And they provided a really great platform for people to give their evidence. And the fact that so many people gave evidence on what the government probably thought, oh, this is a law, nobody cares, we'll just sneak it through and people won't be that interested. And people were so interested. I think that really took them by surprise. I don't know that they'd had such a big response to any FOI inquiry they'd done before. Exactly. Yeah. So I do feel like it was that volume of the public as well. And equally, the Daily Mail has a very good, I mean, the reason it's such a successful newspaper, it does have a very good reading on the public temperature. So the fact that it came out so strongly against the government's, that commission, I think, as well indicated that there was such a strong, that we've now kind of created such a big public community that is in favour of FOI, that a government hopefully will think, well, at least wait for another 18 months before taking it on again.
Well, they were taking a battering from the press that supports the government, of a kind which, in combination with David Davis and the support there is in Parliament on the Conservative side, would have made it very difficult. It would be difficult for the government to get its legislation through Parliament with papers that support the government actually encouraging Conservative MPs to vote against this proposal. The whole exercise, I think, would have been in doubt if they had tried to progress it. Also, I think they were suffering a lot of pain as a result. I don't myself think 30,000 responses from 38 degrees bothers the government very much. I think they can disregard 30,000 members of the public quite easily, but I don't think they can. I don't think they can disregard. Sorry.
They're disregarding 177,000.
Yeah, but I don't think they can disregard the press and the right-wing press particularly, taking a very, very, I mean, the Mail put it on its front page time after time after time, and the Telegraph was very vigorous, and Paul Dacre made a submission in his own name as well as associated newspapers making a submission. Press took this as a major threat which they would campaign against. Now, they never took that attitude. They never took that attitude.
It used to just be the Guardian, and now you really have a good.
That's exactly the point I was going to make, because at the time the Open Government Code was introduced in 1994, which was it was a Conservative initiative, only the Guardian took an interest in it. When the Freedom of Information Bill started, the Guardian kept doing it. We tried to get other newspapers interested. A lot of other newspapers said it's a Guardian story. It's the Guardian's issue. We're not interested. As the Act nearly became law, I was contacted by a major newspaper who said, we want to run a major campaign on freedom of information. I mean, this was 3 months before the legislation became law. I said to them, well, you do realise the Act is virtually there now. It doesn't need much of a campaign. It doesn't need a campaign. It's going to go through. They said, yes, but we'd like to claim the credit for it when it's passed. They actually said that. Now, so what you had, that was what was happening at the time of the Freedom of Information Act. It was very hard to get the press generally to really put their weight behind the legislation for those type of reasons. What's happened now is entirely different. And I think what's happening now is the press is using the Act, and they see that something that helps them and significantly gives them stories and gives them material could be taken away from them. And that has, I think, escalated the whole thing in the press's minds in a way which is very helpful from the point of view of the FOI Act itself.
Yeah, I think it's Lyndon Johnson's first rule of politics, learn how to count. And David Cameron tried to count and found that the majority of 16 just wouldn't do it. He had the Runnymede Tories unhappy. He had Conservative Home running stories against it, and then you've got a very well organised SNP who were pushing extension of the Freedom of Information Act north of the border of the Foyser, and you had the Labour Party, and then on top of that the House of Lords. I think there's something very interesting about the symbolism of freedom of information, which is one of the reasons New Labour didn't back down from it, despite what's said in memoirs, is because if you're against freedom of information, that makes you by default secretive, untrustworthy, and having something to hide. And that's not a trope that you want to hand over to the media very easily. Because if you think, and lots of Labour politicians watched what happened to John Major, once the idea that you're secretive and corrupt begins to stick, then every media story, every scandal hammers that home. And it's that old adage, isn't it, in politics, if you're explaining, you're losing. So if the press are saying something like, why are you taking away our right to information? You need a very good, pithy explanation as to why you're going to do that, and one doesn't really exist that's sufficient. You can't talk about resource burdens on local authorities or chilling effects, and it's very interesting how powerful the kind of symbolism is. I'm maybe going to end by just asking the panel, and by the panel I'd also include me, a single question, which is, okay, we're in 2016, we've given a good kind of overview, I think, of where we are. What do you think is going to be the one or perhaps two issues that is going to dominate openness from now on into the future? Now, we've all set our watches for 18 months' time, so we know what's going to happen then. What do you think are going to be the big issues that are or should kind of dominate the discussion around openness into the future?
Oh, well, I'm going to say surveillance, because I do really worry how free are we able to be as citizens when we hand over to the state the ability to conduct mass suspicionless surveillance. Not just for journalists, it makes it very difficult for journalists, particularly investigative journalists trying to do stories about the intelligence agencies or anybody associated with them. The ability to keep sources confidential, that will be very difficult. But there's a real issue about having a space where where you are left alone, and where you as an individual are sovereign and not the state who can just look, you're completely transparent. So that's where I think the big issue in the future is that unless we've really defined clearly what the relationship is between citizen and state and the power and the flow of transparency, that it should be upwards, looking at that the state is transparent to us, not us being transparent to the state, then that's really going to be the major worry I see in the future.
Right. Well, it's very hard to know what's going to be the big issue in terms of openness. It could turn out to be tied up with the European Union and the referendum, because if the vote is in favour of going, that has a major implication for a lot of our openness arrangements. It knocks out the environmental information regulations. It knocks out changes to subject access and data protection. It would provide the basic, it would certainly be the antidote to Article 10 getting anywhere. Something we've just noticed has just come along in the last 3 or 4 months is the European Union has issued a regulation on an accident near misreporting system. They're requiring that now, although we've had it for years. But what they also say is the system must be absolutely confidential and there must be no disclosure, even in anonymised form, which does not allow the airline or the individual pilot or aircrew staff to be identified, of any information coming out of that system. So you can no longer, and actually the guidance that's come out from Europe on this expressly says there must be no disclosure under national freedom of information laws on this. That is a very surprising and interesting about to come out of Europe, to say that in order to ensure that everybody is absolutely confident about reporting incidents, there must be no right of access under freedom of information, even in a form which can cause no harm.
I suppose one very obvious issue will be the private providers, which is set to dominate debate around open data and freedom of information, the extent to which you need a clause or possible extension to, I think the Independent Commission recommended extension to certain companies of a certain value. I think it was £5 million contracts. The second area that I think is fascinating is in something we discussed, which is the gap between what is happening with freedom of information and what people say is happening. And sometimes what's very interesting is the perception can be as powerful as the reality. And if we do get more statistics on what's actually happening with different bodies with FOI, it's going to be quite fascinating to see that. Okay, it's gone 7:30, so I'm going to let you all go home. I want to thank you very much. I want to thank our two